This letter will go, I'm sure, in the annals of our history as a classic misrepresentation, as a reading material for misrepresentation on the laws on presidential aspirants.
Amama Mbabazi's attorneys have described a missive from the Inspector General of Police and the Secretary General of the NRM barring the former Premier from conducting countrywide consultations as fanciful and superfluous.
The activity we have now relates to presidential aspiration consultations. We do not yet have activities for presidential candidates.
According to Fred Muwema, both the NRM Constitution and Presidential Elections Act do not require a presidential aspirant to be nominated by his or her party. In her June 20th letter, while quoting Article 48, Section 1 and 2 of the NRM Constitution, NRM Secretary General Kololo said that the presidential candidate for NRM shall be selected by the National Conference. However, Muwema says such an interpretation is flawed.
It is wrong for the Secretary General to cite provisions that deal with an activity that has not yet arrived to stop an activity that we have now.
In his letter, General Kayihura says that in the spirit of the letter from Kasule Lumumba, Mbabazi has no locus standi to hold public meetings as a prospective presidential flag bearer of the NRM. However, locus standi means the right to bring an action to be brought in court.
Our client is on course with the law. There is no need for the police to come in at this stage except to provide security at his meetings.
Muwema's view is shared by Benson Tusasire, Makerere University Law Dawn.
Having looked at the NRM Constitution, it does not provide for aspirants. It is silent on this stage of the electoral process, the one about consultation before nomination. Now, you cannot be in conflict with the Constitution on matters on which it says nothing.
The legal ping-pong between the ruling party secretariats and Mbabazi's attorneys has been premised on the definition of what an aspirant is and the ambits of consultations. The NRM Constitution, Article 13, Section 3, and the Presidential Elections Act, Section 3, Subsection 1, 2, and 3, do not require a presidential aspirant to be nominated or endorsed by any party.
The Secretary General must find up some other law, if it exists, that stops an aspirant from consulting, that stops an aspirant from going out to meet the people.
The Presidential Elections Act of 2005, which regulates campaigns and elections in Uganda, defines aspirant as a person intending to stand as a candidate during the election for office of the president. Muwema also says their client has never claimed to be the flag bearer of the NRM. The lawyers have accused the Electoral Commission and the police for being partisan. Political pressures seem to have started, and so have the legal gymnastics. Now, just last week, the Attorney General advised that whatever Mbabazi was doing was within the law and must be allowed to proceed. But police seems to think otherwise.
We are doing the reverse. The police should wait for directives from the Electoral Commission. The police should wait for directives from the Attorney General. Those directives are there, and it is those directions that we shall be seeking to enforce when we engage with the police.
Shiland Wuchere, NTV.